tarde, muito obrigada. Sou Dana Van Brandt, agente cultural do Consulado Geral dos Estados Unidos aqui em São Paulo. Somos muito felizes ser aqui com vocês para esse programa e trabalhar em parceria com a Fundação Getúlio Vargas. E eu quero agradecer muito a nossos parceiros aqui e vamos aproveitar as palavras do professor Alvarez e muito obrigada.
Boa tarde, eu sou Maria Lúcia Padua Lima, aqui da Fundação Getúlio Vargas, da Escola de Direito. Estamos muito felizes em tê-los aqui para assistirmos à palestra do professor José Alvarez, da New York University. O professor Alvarez é especialista na área de investimentos diretos do estrangeiro e tem um enfoque muito importante na área de solução de conflitos por meio de arbitragem e vai nos oferecer essa palestra. Nós queremos agradecer ao consulado americano que, mais uma vez, nessa parceria, nos possibilitou a ter essa presença tão importante de um especialista nessa área. E para nós utilizarmos da melhor maneira possível essa oportunidade, nós convidamos dois professores aqui da casa, a professora Alessandra Mourão, que é nossa professora na área de negociação, especializada nessa área, inclusive prestando também serviços de advocacia nessa área, e professora do GVLO, assim como o professor Rabih Nasser, também nosso professor, que nos honra aqui com a presença, especialista nesta área de negociações também internacionais, professor da escola e sócio da Nasser Advogados. Então, agradeço mais uma vez a participação e o apoio do Consulado Americano, a presença do professor Alvarez. Muito obrigada, professor. Muitas graças. Thank you very much for your presence here now. Eu gostaria de agradecer também a professora Alessandra, ao professor Rabih, e vamos iniciar. A nossa ideia é que o professor Alvarez fará uma exposição, né? Após essa exposição, a professora Alessandra e o professor Rabih farão seus comentários e abriremos para vocês para perguntas, tá certo? Nós vamos manter uma disposição bastante informal, né? E eu gostaria que todos se sentissem à vontade para depois colocarem suas questões. Muito obrigada.
Well, thank you. I apologize that I cannot speak Portuguese, and I was told that my Spanish wouldn't quite do it. So again, thank you all. Thanks to the U.S. Consulate, and thank you for GV for hosting me. And what I decided to do in this talk was actually do more about the regime itself, because I assume that some of you may not be familiar with the foreign investment regime, and then a little, if we have the time, to talk about specifically the Argentina cases as an example of the regime. So most of you are familiar with the concept of foreign direct investment. That's the idea that a foreign enterprise is establishing a company in another host country and does it through, say, greenfield investment, where they establish the enterprise from scratch. Another possibility would be a merger or an acquisition. And what we're talking about with foreign direct investment is obviously assumption of risk, a lasting direct control of an enterprise, and hopefully some hopefully beneficial economic impact on the host country. Having said that, I will say that when the lawyers turned to this regime and started creating these treaties that I'm about to talk about, investment protection agreements, you will hear that they actually did not define it to just cover foreign direct investment. In fact, the definition of investment in the U.S. bilateral investment treaty is something like this. Investment is every form of investment, and here's the list of examples, including an interest in a contract. And so you shouldn't be surprised to hear that among the Argentina cases that have just been decided is Abaclat v. Argentina, which astounded a lot of people. They upheld jurisdiction in the International Center for the Settlement of Investment Disputes, or ICSID, for 60,000 holders of Argentine debt, most of whom never stepped foot in Argentina and just held the sovereign debt of Argentina. And they did so because the Italian-Argentine BIT defined investment in that comparably circular way, or in such a broad way that it didn't seem on its face to be just foreign direct investment. And at least two of those arbitrators, not the dissenter, George Abisab, who not only dissented over 200 pages in furor, he left the tribunal. It's a wonderful decision to read, both the majority. It's just overwhelming personal animosities are demonstrated. But in any case, what those two decided was they would not go with what is called the Cellini test, that some people thought that investment has this intrinsic definition involving those elements of risk, lasting control, and economic contribution to the country, but they would just take the literal terms of in this case, the Italian-Argentine BIT. So if that decision is upheld, and remember, Argentina goes on to try to annul all of these cases, and it's only one decision, this regime may come to be a little different in, say, 5 years' time. It could become the world's bankruptcy court regime, because you can imagine many more holders of not just Argentine debt, but of Greek debt and of Italian debt, all figuring this out. I describe the Abaclat decision, or at least the jurisdictional decision, that's all we have, as a possible game changer for this. So putting that aside, let's focus on the heart of the regime, which was basically about foreign direct investment. And most of you know why countries want it. But as I've said on a number of occasions, countries have a bit of a love-hate relationship with foreign investment. It's like one of those bad girlfriends. You sought her out, and then when you actually achieved the relationship, you said, oh, my God, why? But this is what happens to countries, including the United States. You fight for the foreign investment, and then you discover that maybe it isn't quite what you had in mind. But let's just review what has happened. That is, especially with the end of the Berlin Wall, the collapse, everybody turned to the one model for development that was left. Import substitution didn't seem to work. Socialism didn't seem to work. So let's try capitalism and David Ricardo. And so they went with the theory of comparative advantage, and they said, let's lower tariffs, let's lower investment. And they also went with a sort of Washington consensus model, which says privatize, respect property rights, and deregulate. The three things to do. And these treaties, although preceded this whole notion, really proliferated in the 1990s. And we'll talk about how many of those treaties, but let's make sure we understand why it is that both the subject is important and why countries want it, and at the same time have second thoughts about it. Foreign investment or capital flows are far more significant for globalization than anything else, including trade flows. The amount of money involved in capital flows for direct investment exceeds that in trade, and also it exceeds that in impact. So it's both a qualitative difference as well as a quantitative difference. When you import one more Sony television, you have the difference that makes. But when you import, say, Sony, that is, the company comes in and establishes a new auto plant or something else in your territory, you have cultural impact, you have political impact, and then you have the potential, good and bad, of economic impact. And so it is the engine of globalization, and when it stops, as we learned in the global crisis most recently, it can stop nations as well. So capital does dictate quite a bit of globalization, and countries seek it out for reasons that I think are obvious to you, and you don't have to be in an economics department to figure that out. They hope that it'll bring jobs. They hope that it'll perhaps lessen the trade deficit, because the hope is maybe those companies will export more since they're foreigner. They hope that it will bring added competitiveness. And what they mean by that is that it will up the ante of local companies who have to deal with the foreign company, and they will become more competitive. So this is a virtuous circle, or in the words of President Reagan, win-win. Having foreign investment does all of those things. But at the same time, as we discovered, it also has concerns, economic, political, and national security concerns. So and this has been true of every country, including, I dare say, based on what I've seen of public opinion polls in Brazil. And that is, in the United States, we worried about, oh my God, the Arabs were going to take over, or the Japanese were going to take over. When the Japanese were buying Pebble Beach, which is a golf course, there were newspaper articles all over, aghast. And I wondered, well, what are the Japanese going to do with it? Are they going to take it away? I mean, but in any case, there's always concern, not just when they come, but who are they? Which country, right? Now, the economic concerns that have been raised with foreign investment are that perhaps they won't increase jobs, but that threatened a foreign investor could actually leave with the jobs, or that if they do produce jobs, they will produce low-paying, low-skilled jobs, or that they will produce in places you don't want them to go instead of where you need them to go, so that there are economic concerns about what they will do and whether they will actually do what you expect them to do. There's even concerns they might increase your trade deficit if they come in and start importing more than they export. So all the things that I listed as benefits could not come about, or could be the reverse. In terms of political, no, they don't vote, but at least in my country, they seem to make capital campaign contributions, and many of them are more powerful than the countries that they're in terms of their economic weight, and therefore we suspect that they could corrupt officials or that they could influence them, and so there are political concerns about how foreign investors may operate. And then there are national security concerns. The national security concerns are not just with respect to sovereign wealth funds and state-owned enterprises, but they're particularly acute when it comes to those. That is, some investment is not private investment, it's a government in disguise. So Chinese investments tend to be Chinese government. And the question then is, are they motivated by the market, or are they a secret fifth column inside the social fabric, and they're going to destroy America, okay, or Brazil, whatever? So but remember, there's a serious point to all of these. So that, for example, this last concern has produced in many countries, including the United States, national security screening. So we have Exxon Florio in the United States, which is a law that's been in the books for quite some time, strengthened after 9/11, that permits the president to block a merger or an acquisition if that proposed merger threatens the essential security of the United States. And the way that works is you have to apply to a committee, an interagency, executive agency of the federal government, to demonstrate, if you're a foreign investor, what you plan to do. And if you are, for example, a Chinese entity, that is a very serious scrutiny. And you may have heard of the Dubai port deal. This became a huge political issue when it was discovered that, yes, an Arab country was purporting to take over a port facility in the United States. The national security issues loom large. Congress was very up in arms about it. But the U.S. isn't the only country that worries about this, and it's not just about whether it's a state-owned enterprise. It's also about what enterprises are being taken over in a merger or acquisition. Because if the foreign investor, even if it's a private foreign investor, plans to take over the last maker of a particular microchip that is used in a defense industry, people worry about whether that microchip will be available when you need it. And keep in mind one more thing on national security. After 9/11, the national security issues changed a little bit inside that agency of the U.S. federal government. They used to just worry about examples like I just talked about. Are they taking over a defense manufacturer? But after 9/11, you can see why some of those agencies were worried about a foreign entity that was going to build a huge skyscraper in New York and knew all the physical vulnerabilities of its blueprint. So now you're worried about infrastructure. Now you're worried about things that aren't just limited to aviation or making arms. So national security is a complex issue. I raise that because it suggests that this is a picture that is always, I just saw the book out there, so I can't resist, shades of gray. Not 50, but enough of shades of gray with respect to whether you like foreign investment. So in terms of what we have, so when the lawyers got into the picture, things got very complicated. That's what lawyers tend to do. And what we now have are bilateral investment treaties, some 2,600 of them. The United States has 41 bits with many countries that there are much more foreign investment of the U.S. there, and very little of those countries investing in the U.S. But the U.S. also has 19 of these free trade agreements, including, most famously, NAFTA's Chapter 11. And 19 that I'm talking about have an investment chapter. And the reason NAFTA is so important, the North American Free Trade Agreement between the U.S., Canada, and Mexico, is that that's the one country, Canada, that does invest in the United States. And guess what? They sue. So since NAFTA came into force, who is the third most sued state for investment issues? The United States. Okay? That leads to my title. That's why it's called the Evolving International Regime. Because when you're sued about 18 times, you don't like it. And so you decide to change the rules to sort of prevent future lawsuits. But we'll get into that. Then there's things like this, the Energy Charter Treaty, which is a multilateral agreement on oil. And then there are investment measures taken within the WTO. So this is a regime that is complicated because even though it is mostly bilateral, and between these two, we have some 3,000 agreements. There are 300 FTAs around the world, so 2,600 bits and 300 of those. There are some multilateral measures that states have, and just to complete the picture, you have, if you study public international law, you will have known about some of these General Assembly resolutions. If you study human rights, you might have gotten into the OECD guidelines. And then we have the Code of Capital Movements within the OECD, and we have the World Bank's International Center for the Settlement of Investment Disputes and other arbitral mechanisms, which even though they do not issue rules about how you treat investment, they are the forum for settling disputes. And then you have political risk insurance, including the multilateral agency that provides this, and these make it possible for many investors to go into one country because they deal with political risk. This is a world that is not like the WTO because there is no one single institution and no one single treaty that governs it. What we have is a spaghetti soup of agreements, some of them more favorable to the investor, some of them less. And the spaghetti soup applies even here. That is, the 2,600 bits are not all the same. They've been negotiated since 1959, when Germany started this, and the early U.S. treaties, as we'll talk about, were very protective of investors, but the later ones, post-2004, less so. Keep in mind what this means is that what we have up here is that there are 180 countries out of roughly 200 that have at least one bit in place. So there are more countries involved in this regime than are members of the WTO. Brazil does not have a bit. It has successfully avoided all of this. And the question that always comes up, and I duck everyone, is should it join? We can discuss that in the Q&A. But there are serious questions about whether countries need bits, but the truth is most countries have at least one. And remember, one may be enough depending on what you think this is for. If a bit is what political scientists call a signaling device that says, I'm open for business, concluding one with the United States is not a bad way to send that signal. And maybe you don't need that many bits to send that political signal. And keep in mind there are many reasons why countries enter into bits. Many think it will bring foreign investment from the particular country they're negotiating. The empirical work on that is mixed. That is, there's a whole book collecting the empirical work by Lisa Sachs and Carl Savant. And it's a mix in that some bits seem to do the trick. There's mild evidence that entering into a U.S. bit on some occasions may help. But other evidence suggests it doesn't, which makes all the sense in the world if you look at business studies of why foreign investors choose to invest. If you ask CEOs why they choose to invest in Brazil, the law, whether it's a treaty or even the law of Brazil, is usually not in the top 10 answers. You may get things like, oh, well, they have a big market, consumers, and there's more room for Starbucks here than there is back home. I have a Starbucks in my bedroom, as far as I can tell. So there's the market, there's the availability of resources, there are all, and I'm talking about mineral or oil, there are many other factors other than do you have a bit. So it makes sense that bits don't dictate this. But you may want to enter into a bit in order to protect existing investments, foreign and others. That is, you may want to encourage the foreign investor who has already had sunk costs to expand and not to leave, even if it's cheaper now to produce in China than it is in Brazil, right? So there are many reasons. Or you could choose to conclude a bit just to say you're friendly with that country. That is, this is a political statement. And remember, it is not rare. When I was at the State Department, this is how I got into this stuff, is I was at the State Department negotiating bits when nobody wanted them, with a few exceptions. Grenada comes into the U.S. He was having, this is the Prime Minister of Grenada, before we invaded. No, wait, maybe it was after we invaded. I have to remember. And he's having minor surgery in Washington, D.C., calls up the office at the State Department and says, I'd like to sign something while I'm here. Something just to make it look better. So he said, how about a bit? And we said, sure. And that's how we got the U.S. Grenada bit, which happens to look exactly like the U.S. model at the time. Wow. Well, there was not much negotiation. So that's an example of why some countries choose to enter into bits. Now, I apologize, but I'm not going to go through every one of these slides. But this one's pretty important. This is what a typical bit or an FTA has. National and most favored nation treatment. Most of you know this if you studied the WTO, although there's some controversy as to whether these terms should be interpreted the same way, because what is a similarly situated investor as opposed to a similarly treated product? It's not the same thing. But the idea here is you're supposed to treat the foreign investor from the country that you've signed one of these treaties the same as your own national investors, and you're supposed to give that investor the best deal you have. That is, to foreigners. So if your best friend is the UK and you've given some cozy deals to the UK, they get that too. That's MFN. Then in addition, no arbitrary treatment, no discriminatory treatment. Now you might ask, why this if you already have this? Well, This is where creative lawyering comes in. Maybe this is all about comparisons based on nationality. But maybe you're not supposed to discriminate by sector. So you can't just benefit all the oil people or all the automakers, right? So, and then there's arbitrary, which is most of the tribunals have said no rational government would have done this. Fair and equitable treatment. This is the favorite one for investors. They win most of the time, at least if they're going to win. And by the way, the evidence suggests that states still win most of these cases. Okay? But when investors win, as in the Argentina cases, this is the winning one. The one that are most likely. Why? It's the Vegas one. Whatever you did, it was unfair. It was inequitable. Okay, you make an argument about that. Now, the tribunals have tended to try to put some content into this. So one of them have suggested, many of them, it's legitimate expectations. What this is protecting is legitimate expectations. Now, what's a legitimate expectation? Here's an example from the Argentina cases. If you were welcomed in when Argentina privatized, or I'm sorry, gave a concession to utilities, say gas utilities or electric utilities, and when you came in, the government concession, the tariff regime, was something along the following lines. You will get a reasonable rate of return, and as conditions develop, we will renegotiate to make sure your tariffs ensure a reasonable rate of return. What the tribunals have tended to say is that specific promise made in the specific licensing arrangements to those foreign investors were part of the legitimate expectations of the investor. Right? Now, what do you do about differences in the state? Is it relevant that there was a serious economic crisis in Argentina when Argentina decided not to abide by that? What you're now seeing in the Argentina cases is the more recent tribunals suggesting that fair and equitable treatment has to take into account the changing conditions in a country. So that would be unfair and inequitable under normal circumstances is not in an economic crisis. That's what I mean by saying the evolving regime. And why I also say that if we get there, the Argentina cases, after 10 years, which I elaborate in numerous tables, and you have one of them that didn't make it to the slide, although if you read some scholars and you read how some governments have dealt with the Argentina cases, they portray it as a graphic novel of evil and good. That is, Argentina is good, this regime is bad, and the best thing to do, according to the Osgood Hall statement signed by 37 of the most prominent international lawyers, and academics, including Marty Koskanemi, just Google Osgood Hall statement. They say this regime should be dismantled. Countries should not enter into bids. And if you're one of those countries that have had an arbitral award rendered against you, you shouldn't pay it if you don't think it's fair. These are lawyers saying violate not one, not two, but 3 treaties. Your convention, the ICSID convention, and the BIT. Okay? They feel so strongly that this regime is unjust and inequitable. And those are the people I call the graphic novelists. But the truth is, if you look at at these cases, it's a Shakespeare story. It's Macbeth. It's complicated. It is back to the shades of gray, but not quite as badly written. Full protection and security. Full protection and security is that if the government normally provides police protection, and it didn't, then you could show this. So if a bunch of you riot, and you're private actors, but you riot against a foreign investor, and normally you would have police protection, but somehow the police weren't there that night, that's the connection to the state that suggests a violation of full protection and security. And of course, you get the all-time favorite, prompt, adequate, and effective compensation if you are expropriated. big bad Hugo Chavez does nasty things to you and takes your property, he's supposed to pay promptly. And by the way, if he doesn't, how does the law take care of promptness? Any volunteers? Interest. Okay. Adequate. What is adequate? Fair market value, which means you get a bunch of, the green eye shade types, the accountants, and they will try to estimate the worth of that property and give you what it was worth before anybody announced that they were taking you over. because if the announcement is made, somehow the price drops. Effective. So if Hugo Chavez takes you over and he says, yes, I'll pay you, but in my good friend Cuban pesos currency, that won't do. That's not effective. So many of the provisions describe the type of hard currency that it has to be in. And it also provides for subject to regular regulations for transfer that you will be able to take capital in and your profits out. So those are the typical provisions. However, I like to point out, even though we're not going to spend any time, that each treaty provides for a slightly different way of putting it. So this is an example of the U.S. model of 1987, no less favorable than that accorded in like situations, right? Now, what if a treaty, and many of them do, not have that? What if it just says, on a basis no less favorable than that accorded to investment, without that? So you can see why an arbitrator may face different decisions on what the meaning of national treatment or not. Or what if it says, in like circumstances, right? One word. You guys are creative lawyers. You know what you can do with this, okay? So this is just an illustration of why the particular language matters. So here we have the typical statement for fair and equitable. And then this is something that I would like to point out that I didn't mention. Each party shall absorb any obligation it may have entered into with regard to investments. That is known as an umbrella clause, okay? And there are many, many versions of it with different language, and there are huge issues of interpretation. What is an obligation entered into? Is it just a contract that the host state has actually concluded with a foreign investor? Does it include the licensing arrangements or the regulation? Is that also an obligation entered into with regard to investments? So we have differences of what that means, and that's just the umbrella clause. Okay, so this is just an example of, this is the expropriation clause, and it is in the U.S. model quite broad, either directly or indirectly through measures tantamount to expropriation or nationalization. So it is not just, according to this language, a formal nationalization decree issued and signed by Hugo Chavez. It could be tax measures that wipe you out, or a regulation, environmental one perhaps, that may lower your economic profits so much that it is tantamount to expropriation, right? And notice, this is not a clause, if you read it closely, that says, if you have a public purpose, I don't have to pay you. There's an and. That is, you have to satisfy all of those things. That is, you always have to pay if it's an expropriation, no matter whether or not you have a public purpose. If you don't have a public purpose, it becomes an illegal expropriation, and we will just add to the damage, and including perhaps anticipated profits beyond fair market value. Okay? But this is not, do not read this as, oh, if I have a public purpose, environment, whatever it is, if it constitutes this, you have to pay. That's what this says. And then, of course, it spells out what fair market value is in that clause. Okay. And then this is the characteristic that distinguishes this regime from most other regimes in international law, with the exception of human rights. And that is, it creates the investor as the third-party beneficiary of these treaties and gives the investor the direct right to sue the host state if this treaty is violated. This is investor-state dispute settlement. Radically different from the WTO, where one state sues another, but very similar to, say, regional human rights courts, where an individual can sue a state for a violation of human rights. Okay? In both cases, what you're doing is creating in the investor a private attorney general charged with enforcing this regime. Okay? Very unusual in international law, with the exception of human rights. This is just the definition of investment dispute, and keep in mind that it includes all of this, but also any breach of the treaty is an investment dispute. Now, the dispute has to be consultation and negotiation, but not typically in this treaty. It doesn't say much more. Some treaties say you have to wait 18 months, but very few of them actually say you have to go first and exhaust local courts. Typically, you do not, and the U.S. treaty does not. So what it does is, this is fascinating, okay? In this sense, you have to be a lawyer to be fascinated, but okay. So here, it says, it sounds like it says, if I have a contract with the host state in which I was stupid enough to say I would go to Argentine courts to settle any dispute, you're stuck with it. Not so fast. That is, you go to previously agreed dispute settlement subject to paragraph 3. And I actually personally drafted. That's my one thing, subject to paragraph 3. And what is that? You can always go to ICSID, okay? So even if you have a contract that says go to Argentine courts, under this treaty, you can violate that contract and go here with the excuse that this is a treaty breach, not a contract breach, although if you're asserting the umbrella clause, it may also be a contract breach, okay? And so this gives you the option, you as the investor, of going there. And it also provides that the dispute, the only exception is if you have been stupid enough to go to national courts. This is known as the fork in the road. So under this treaty, you have a choice. You either go to Argentine courts or you go straight to ICSID. And this treaty provides that the state consents to these disputes. Of course, separately, it would have had to consent to the ICSID convention. But of course, when you negotiate this, you figure that out, whether the state is an ICSID party. But this is the consent given by the state to these disputes. Because under ICSID, you need two consents, consent under the convention, but also consent to these disputes. And this is advance consent to any disputes that could ever arise under this treaty. You don't know what they are. Prospective consents. So Ian Paulson calls this arbitration without privity, because there's no contractual consent each time. The privity is the treaty, so I actually not sure that's an accurate term, but that's what he calls it. And then, for those of you who know the WTO and investor-state dispute settlement, here are the differences. In the WTO, the states control whether they send the dispute and contest it. They also control what claim to make, what legal issues to raise. So some of you may be aware that the U.S. and Cuba don't get along. And there's a Helms-Burton law that some people think violates the WTO. Yet we don't seem to have a dispute in the WTO that settles the legality of the Helms-Burton, meaning that somebody has leaned on somebody not to bring that complaint because states retain control. And probably the U.S. said something like this. You know, Europe, I know you have a problem with Helms-Burton because you don't believe it violates, it actually upholds my national security. But guess what? We have a problem with some of your issues that you claim are national security. France says the yogurt industry is in its national security. And so there's a cozy relationship among some states not to bring some troublesome claims and not to make law through those claims. Not here. Here, somebody else, that private attorney general, all of you who have been hired as lawyers for those investors, choose to decide, without permission from the U.S., to sue Argentina and claim whatever, including, we don't believe you really had an emergency, Argentina. Therefore, we're going to do this, even though we think that means that the arbitrators get to decide whether something is in the essential security interests of Argentina. Just like we don't decide that in the WTO, in this regime, somebody else gets to make that claim before the arbitrators, and the arbitrators have to settle that question. Remedies are different. In the WTO, the remedies tend to be prospective. That is, the goal is to get the measure removed. There is the possibility, and sometimes it happens, of retaliatory tariffs, but those are for the future to try to anticipate what the harm might be and not retrospective to actually compensate a particular individual. This regime, the investor regime, is all about tort damages. It's all about giving money to a private party. This regime is about sort of mobilizing shame to try to get a state to comply by removing protectionist measures. And therefore, for these reasons and many others, the impact on sovereignty is perceived to be higher for investor-state arbitration. That is, states, and the evidence is, lots of states are having second thoughts about all of this. Australia, 6 months ago, announced no more investor-state arbitration in its future bids. It said to the world, we trust our courts, you should too. That's what it said. And of course, we all know about Bolivia, Venezuela, Ecuador, the bad boys of this hemisphere, all of whom are saying, we got to withdraw from ICSID or stop negotiating these treaties or terminate the ones we have. But that backlash is also evident, I think, in the U.S. and including through the evolving U.S. model that has shrunk investor rights and vastly expanded state discretion. Now, so I won't cover this. And then there is one comparison that I do want to make, and that is human rights treaties can sometimes also respect property. But when they do so in a way that is a bit different because they include as part and parcel a balancing test in the property right, unlike the expropriation provision I've just given you. So the European Convention, on the face of this Protocol 1, is a balancing test on the protection of property. Very different from the text that I've just provided you. Now, for those of you who are familiar with human rights, these are the differences. So I've just discussed that obviously the human rights regime has some similarities with investor-state arbitration. They both allocate rights to the private party, and some of the rights look awfully similar. That is, non-discrimination, fair process, property protections. But here are the institutional differences. So a court like the European Court of Human Rights has full-time judges, hearings open to the public, as well as claims and decisions to the public. You have to exhaust local remedies before you go there. And its emphasis on preventing, just like the WTO. That is, yes, the regional courts sometimes give damages, but they tend to be small. The emphasis in those courts, up until now, has not so much been victim compensation. It's about mobilizing shame against human rights perpetrators so that they don't do it again. Nunca más. So, balanced property right in this regime compared to this regime. Ad hoc arbitrations. And here, some of these things are changing a little bit so that ICSID is more transparent, but we still have not gotten to the point where every investor-state arbitration we can be sure of is public. Because some bids provide to the investor the option of going to Stockholm or ICC or UNCentral, in which case we will never know unless the investor and the state agree to release the opinion. So what we have are the publicly available investor arbitration awards, but it could be the tip of a very large iceberg for all we know. Exhaustion, typically not required, not under the fork in the road, and emphasis on remedial damages, and the property right is not typically subject to explicit balancing. So what we have, let me just, this results in these three problems, actually one more, 4 problems, and that is a perception that this regime has a vertical disconnect, a democratic legitimacy problem. Top down, that the democratic laws are not respected. You can trump what a democracy wants to do through a treaty. Many people say a treaty, even though it was ratified by a Congress some time ago, doesn't have the democratic legitimacy of the law as determined by a particular administration or a particular Congress. There's horizontal inequities alleged. This does not result in a level playing field among states. I mentioned the U.S., 18 claims, 0 losses. Could be they're fantastic lawyers in the United States State Department. Or it could be that some investor arbitrators get the message that if they hand a defeat in one of these very prominent cases to the United States, somebody walks out of NAFTA. So powerful states may get their way even in this depoliticized system. So I argue that politics doesn't stop at the door of ICSID. It seems to be there, and that may help to explain why Argentina is sometimes winning in these cases, because I think after the global crisis, states are saying, but for the grace of God, go I. That is, I could have been doing those nasty things. And in fact, in the global crisis, the United States and some Western governments took some measures under TARP legislation where they benefited U.S. automakers, U.S. banks, and nobody else. And some academics looking for expert witness jobs, I suspect, have written about how that violates existing treaties. So far, no claims, or at least no public claims, under TARP. But of course, states are now running scared about, can I do something about the last crisis, or will I face Argentine claims for that? Ideological. You can guess what those are. If these treaties pursue the Washington Consensus model of development, and you disagree with whether that leads to development, you've got an ideological problem with this regime. That is, it pursues the wrong economic model for economic development. And we'd like to, for example, have performance requirements. And these treaties tend to ban those. I didn't even mention that. All right? So you can't say you can only come in if you export X amount. Under the U.S. treaty, that's a no-no. And then rule of law. So the problem is this regime produces inconsistent law, and the result is unstable, unpredictable law, and not either the investor or the state knows what it is. Now, I tend to think that those are all exaggerated, but I'm running out of time. So let me just say that I'm going to leave with the organizers the Argentine tables, which goes through, as of March 2012, all the Argentine cases that we have to date. And if you go through those tables, and including the one that was distributed, you will see, with the exception of the issue that you have in front of you, which is the definition of necessity and what it means, which has led to 5 different approaches on the right-hand side of the page. On most other issues, what we are getting is actually consistent law through the Argentine cases, and increasingly deferential to states' regulatory interests, as I mentioned, not just with respect to FET, but with the definition of arbitrariness, with what happens on liability. And just keep this in mind. The critics of this regime have latched on to the Argentine cases. And one of the reasons is, look at this, a crisis, and the state faces $80 billion of claims. Well, if you actually take a look at the results, what Argentina is now facing is $500 million. Now, that's a lot of money, but it ain't $80 billion, and it does not compare to what Argentina paid the IMF, right? And we're not actually yet destroying the IMF. So there are comparisons here to be made, and as I say, if you actually take a look at the results in the Argentine cases, it's quite a mixed bag. And my own personal opinion is that Argentina did some stupid things, including announcing to the world that it will not renegotiate or negotiate at all tariffs, even though it promised to do so. And so some of these cases say that's what you did wrong. Not that you took these emergency measures, but that you refused to negotiate when you promised to do so. And so I have a great deal of sympathy for those, but keep in mind, do not believe a word I said on this point. I'm an expert witness in all of these cases, independent, but hired by the investor to interpret what the U.S. bid meant, because the U.S. treaty, that is the U.S.-Argentina Treaty of 1992, was based on the U.S. model of 1987, which I had some role in drafting. So I had a view, but when you think about it, why should I get to testify on a legal question? These are smart arbitrators. They should figure it out. But if they want to hire me, I'll do it. Okay, thanks. Commentators.
Thank you, Professor. Now we give the floor to Professor Alessandra to make some comments.
Okay. Will you excuse me, Professor, if I speak in Portuguese?
Oh, absolutely. No, I'll just listen.
Okay, thank you. Just, I promise translators I will speak very slow so that Professor will get as much as possible, and also counting on your knowledge of Spanish. But anyway, since we are here with most audience and being Brazilians, I decided to address the talks in Portuguese. Bom, o meu maior interesse em aceitar esse convite para participar da mesa, logicamente, tem a ver com o contexto econômico. Quando se fala em crise global, todos nós que militamos e atuamos com negociações e com contratos internacionais, estamos muito atentos ao impacto do que está acontecendo no mundo econômico com os contratos, com o dia a dia das empresas que nós trabalhamos. E quando fala em Argentina, então, quer dizer, nossos sentimentos pela Argentina, do futebol até os negócios, são muito grandes. Então, falou que o professor Alvarez vinha aqui nos falar, e um profundo conhecedor das brigas do governo argentino, da Argentina com os investidores. Eu fiquei, assim, muito entusiasmado de ouvir, aprender e ainda pegar um assento privilegiado aqui na frente. Então, essa rápida e simpática conversa já trouxe uma série de informações muito interessantes. E eu, como professora de negociação e estudiosa de negociação, tomei a liberdade de ler um pouco dos escritos do professor, e o que me chamou a atenção dentro da minha área de conhecimento foi um argumento trazido pela Argentina nas arbitragens, no sentido de que ela achava que os investidores não deveriam ter os seus pleitos considerados pelos tribunais arbitrais, porque com alguns deles ela estava num processo de negociação. Então, essa negociação em desenvolvimento, ela impediria que os investidores fossem até os tribunais arbitrais. Isso, para a minha área, me chamou muitíssimo a atenção, e é sobre isso que eu gostaria de fazer, então, o meu comentário, porque quando trato com os alunos sobre o tema de negociação, eu falo muito com eles com relação a pensar estrategicamente quando negociar. O timing, a questão do momento de negociar é muito relevante. E que nós, negociadores, nós vemos a arbitragem ou mesmo a corte judicial como uma alternativa. O nosso foco é, primeiro, vamos tentar negociar e resolver a controvérsia, o conflito. Mas sempre de olho de que há sempre uma alternativa caso esse acordo, caso essa negociação não seja bem sucedida. E aí a gente tem a arbitragem e o Poder Judiciário, mas não no sentido de que alguma coisa obste a outra. Daí porque a minha surpresa nessa alegação. E pelo que eu vi, e o professor me corrija se eu estiver errada, esse argumento foi francamente rechaçado pelos tribunais, no sentido de que o fato de ocorrer uma negociação em andamento não proibiria os tribunais de acolherem aquela arbitragem e resolverem o caso, né? E olhando um pouquinho o noticiário da América Latina nos últimos anos, eu me lembro que, se não me engano, em 2008, o Evo Morales fez um acordo com algumas empresas de gás depois, quer dizer, ele fez o acordo depois de instaurada a arbitragem. Antes dela ir para frente, ele fez um acordo de, sei lá, alguns milhões de dólares, mas em nenhum momento a Bolívia teria alegado esse tipo de impedimento. Tanto que, muito pelo contrário, ela preferiu fazer o acordo do que deixar que a arbitragem continuasse, e não levantou na arbitragem, pelo menos eu não tenho conhecimento, que eles tenham argumentado que aquela arbitragem não poderia ir para frente. Refletindo sobre isso, e aqui dentro do nosso sistema brasileiro, quando nós pensamos em, por exemplo, o ajuizamento de uma demanda, uma das condições da ação é o interesse de agir. E o interesse de agir tem como base o binômio necessidade e adequação. Então, muito se discute, aqui no meio acadêmico, né, quando nós falamos do binômio necessidade e adequação, necessidade que se resume em dizer que eu, para a satisfação do meu direito, necessito dessa ação, se eu não deveria sempre tentar o caminho da negociação e só depois de demonstrar que o eu exauria que eu poderia bater as portas do judiciário. Tanto que existe uma passagem típica nas petições, né? Esgotadas as tentativas de resolver amigavelmente, vem fazer o seu pleito, né? Então, considerando tudo isso, eu tive refletindo que, no meu entendimento, realmente esse era um argumento para não ser abraçado pelos tribunais, mas gostaria de colocar uma questão aqui para o professor. Hoje, eu tenho advogado muito para que meus clientes insiram nas cláusulas de solução de controvérsias, que eles façam fases. Uma primeira fase de negociação, eventualmente uma segunda fase de mediação e o terceiro passo, a arbitragem ou, eventualmente, o Poder Judiciário. Pois bem, eu não vi nos escritos sobre esses casos da Argentina que eles tenham alegado que havia uma previsão deste tipo nos contratos. O que eles estavam alegando é que, em função do BIT, se não me engano, teria que se aguardar 18 meses, ou eu gostaria que o professor explorasse um pouquinho esse lado, porque eu fiquei bastante interessada. Se eles simplesmente alegaram a uma regra geral que submete a nossa controvérsia necessariamente ao argumento da negociação para depois irmos para a arbitragem, ou se eles alegaram que havia algum dispositivo contratual. Eu acho que se constasse de uma cláusula contratual a necessidade de se passar por uma fase de negociação com prazo razoável, até porque nós temos os problemas de prescrição, também não podemos ficar eternamente negociando e perdemos a oportunidade de entrarmos com os nossos pleitos. Se o professor entende que, havendo uma cláusula específica estabelecendo uma fase inicial de negociação com um prazo, digamos, de até 90 dias, e que essa cláusula teria que ser realmente atendida pelo investidor, e o tribunal aí sim poderia se recusar a atender, a dar início à arbitragem somente depois de exaurido aquele prazo previsto em contrato. Como professor de negociação, é essa a grande coisa que eu gostaria de perguntar.
In 2005, there has been a meeting in the Confederation of the Industries here of Brazil, to discuss the Brazilian agenda regarding investment treaties, right, in 2005. And there were investors invited, and two of them representing Duke Energy and Endesa, a U.S. company and a Spanish company, said very clearly, our investments in Brazil do not depend on the existence of a bid. This is not a relevant factor for us. But they said at the same time, when investing in other countries, this may be an important factor, right? And the representative of the Ministry of Foreign Affairs of Brazil at the meeting said that the working group that was working on this issue as of 2003, they reviewed the bids that had been signed by Brazil, and they felt very strongly that they are very directed towards protecting the investors, right? And that for this reason, he did not see many chances of them being ratified. Not surprisingly, since 2005, not much has happened regarding this subject in Brazil. There is today almost widespread impression that Brazil has done well in not ratifying the bids that we signed in the 90s, right? I would like to put a little bit in context this attitude of Brazil, and so that if you can comment on this, right? There are obviously, as you mentioned, three levels of regulation regarding the foreign investments. There is the multilateral level, and you mentioned we have some rules at the WTO specifically regarding trade-related investment measures, right? There is the regional level, and there is the bilateral level. In the multilateral level, Brazil has been historically suspicious against the attempts to include new subjects in the WTO. This was, in the Uruguay round, in the first half of the Uruguay round until 1990, Brazil led the opposition to the inclusion of these new issues in the multilateral agenda, including investment, together with India, basically. But in the second half of the Uruguay round, from 19 to 1994, Brazil ended up accepting some commitments regarding investment, right? And this was part of the trade-off in the Uruguay round. But Brazil made an effort to keep them limited, these commitments. So the TRIMS agreement is much more limited than it was supposed to be if the United States had prevailed all that they wanted. Since then, this issue has been put in the agenda of the multilateral negotiations in 1996, but it was withdrawn in 2004 again. And now it's not part of the Doha negotiations, right? So this is the multilateral level. And Brazil is probably happy with that. Brazil did not make much effort, I think, to take it out of the negotiation this last time. But obviously, Brazil was not sad about that. On the regional level, you may know that in Mercosur there is a protocol of 1994, the Colonia Protocol, about the protection of investments. That was agreed by the 4 countries, but was not ratified by any of them. So it didn't come into force, and there are no prospects nowadays, and obviously I think Argentina doesn't want to hear about that, of this coming into effect, this protocol. You also know that investment was one of the contentious issues in the negotiation of the free trade area of the Americas, right? It was a sensitive issue for Brazil. The chapter of investment was very much inspired by the NAFTA chapter. This was probably one of the reasons on the Brazilian side why this negotiation failed, right? On the bilateral level, Brazil signed in the 90s, and I think very much because of the circumstances of the Brazilian economy at the time, right? And because of this wave, this rush to sign bids, Brazil signed 14 of them and sent some of them to Congress. In Congress, they faced a harsh opposition from some parties, and they never went through, so they were never ratified. In 2002, they were withdrawn from Congress, so the executive stopped seeking approval of these agreements. And since 2003, they are being reviewed by a working party, interministerial working party, and everyone knows that this will be abandoned, basically. Right? So, where we are now, based on this context, where we are now, I will give you an opinion, and if you can please comment. Brazil is not only an importer of capital anymore, right? It used to be. Now it's not the case. Brazil exports also capital, especially and in many cases to countries that have some kind of instability, either economical or political. And this is a recent phenomenon, 5 or 6 years, right? At the same time, the economic situation in Brazil is different, is more stable now, right? And probably some kind of attitude towards the investment regime is necessary, a more proactive attitude from Brazil. So I see two possibilities. One is Brazil helping to make a new model of bids that could be acceptable for Brazil, either as an importer of capitals or an exporter, and Brazil could offer or try to negotiate this new model with other countries. And the second step that today may make sense is because of this spaghetti soup you mentioned, right? I wonder whether it's not the case of making an effort again to reach some kind of basic guidelines regarding investments in a multilateral level, right? This effort was failed in the WTO, failed at the OECD, but I wonder whether this wouldn't be in the interest of Brazil, of a country like Brazil, that is not part of this regime, especially has no bids, to have some kind of regulation in the multilateral level with some principles, MNF, most favored nation, national treatment, even fair and equitable treatment with some specification of what that means, right? So probably Brazil could have a proactive role in shaping these multilateral rules that could be valid for anyone. When I talked about this with government officials, they are a little bit skeptic because they say Brazil is one of the few countries that is not engaged in this subject. So the other countries may not have the interest of listening to Brazil, as they already signed bids that are in place, right? So, what would you comment on that? Thank you.
So these are two excellent comments, and I appreciate both of them. Let me address your point about negotiations. So I'll leave these, but this is the Argentina cases where we are 33 decisions, 17 on the merits, and so forth. And they involve 9 different bits. 11 of the claims are against the United States, but keep in mind there are all these other countries against Argentina. But it is fair to say it's Argentina not versus the world, but at least versus the U.S. and Europe. Those are the claimants in these cases. And many of the cases involve more than one bit. Okay, for various reasons, the investor could have qualified corporate nationality in more than one place. These are the damage awards that I mentioned, and they include, and again, I'll leave all of these, the annulments, with the bottom total being, this would have been the gross total, but after the annulments, it's down to $524 million, as I've mentioned. But the reason I wanted to put this up was in response to your 18-month question, among other things. So that these are the recurrent jurisdictional issues in the Argentine cases. So Argentina raised a number of things to try to avoid arbitration, as you've suggested. And on most of them, as you see, my conclusion is the results were consistent across the cases, on fork in the road, on interpretation of Article 25, on what is an investment. The one exception is this business of 18 months. So that some of the treaties were sympathetic to what you have to say and said you cannot initiate an investor-state dispute settlement under arbitration for 18 months. And I had to produce a separate table because they were inconsistent on that. And so these were the actual arguments raised by Argentina. And on 18 months, they said we need to wait 18 months, including for negotiations, because that's what the bid says. And this is the result of the 18-month. Some of the tribunals said that it was not an absolute impediment to arbitration to have an 18-month clause, and that's BG. And that was such an astounding decision that the U.S., because it's an uncentral decision, vacated the decision. They disagreed with the arbitrators, okay? Because it does seem to ignore. It says, wait 18 months, and they said, we won't. And this one, Abaclat, this is the sovereign debt one, they said this was something we have to consider as to whether or not Argentine rights were adversely affected. So we actually had testimony and experts as to whether there were adverse effects, and that's the test they applied, and so they said we don't have to wait 18 months. This one, TSA Spectrum, said it would be highly formalistic to apply 18 months. The reason? It was 17 months. And so they said, 1 more month? Are you kidding? You mean everything has to be filed all over again because we didn't wait? This is the most controversial. This says, wait a minute, Argentina signed some treaties, see the U.S., that doesn't have an 18-month. And there's an MFN clause in this one. So we'll go over there and get one that doesn't have an 18-month clause. That generated dissents and very controversial, at least in the academic literature, because some people think that an MFN clause should not in principle apply to procedural requirements like that. Okay? And in this case, Argentina just screwed up and never said anything. But anyway, so what we have are different rationales, but mostly Argentina lost on the 18-month. Now, I happen to disagree. I think they should apply the 18 months and wait those 18 months. But what you raise is that, and we're starting to see this in some treaties, they are inserting more preventative approaches, and you could do that in a treaty. You could say not just 18 months, here are the steps you have to do, here are mediation and so forth. You could take a page from the WTO, which has a rather regular set of rules about what you're supposed to do before a panel is even established, right? With the Argentina cases, I would say that it is, the reason I'm not as appalled is because they actually did do, in the cases that I know, CMS and others, this became an important issue, not because the treaty required negotiation, but the contract did. And so in order to determine whether it was a violation of fair and equitable treatment, the claimant had to prove that you didn't fulfill the negotiations anticipated in the contract. So the claim was, Argentina, you stopped negotiating, and it's now been 6 years, right? So, or 7 or more, right? Because remember, these claims have been pending quite some time. In fact, if you go back to my graph, the first one, you'll see many of them are not even finished. So we could have another conference 5 years from now. But then DV Argentina, 11 years to get to a decision, okay? So arbitration is not cost-free, speedy, or any of those things, right? So I would say that in the Argentina cases, it actually did become an issue with experts, including obviously the company versus Argentina, as to whether there were any good faith negotiations processes left. But I do agree with you that one of the things you could do is, since this overtakes the contract, this treaty, is at least in the treaty provide for more steps. And in fact, there's some academic literature suggesting that given how adversarial this whole has become, how many lawyers are involved, how costly and everything else, let's put in more mediation and other preventative steps. So I do agree with that on that. Does that help answer the question? Now, so in this table, the other reason I put it up is the last table is actually the most important, which is this one. This is not the Argentina cases. This is the U.S. model bid across time. And that's what I would suggest Brazil needs to get educated about. That is, since Brazil has been not negotiating this since a long time and looked at treaties in existence, and I would suspect only some of the treaties in existence, they're possibly not aware of the more current treaties in existence. This is U.S. Peru. This is U.S. Singapore. This is China's model bid, as well as the U.S. model bid. And every one of those rights that I put up has been narrowed over here. Investment, starting with the definition of investment, now we're getting much closer to the Cellini test over here, requiring risk and so forth, so that it becomes harder under this to bring a stockholder claim, okay? And here, this is just more about the definition of investment. National treatment has been narrowed. MFN has been narrowed. New exceptions have been incorporated, including to make it more consistent with the TRIPS agreement. And here are some of the hedges on national treatment and MFN. And this one. Where is it? Here it is. This is the umbrella clause. It's gone. No umbrella clause in the U.S. model treaties altogether, okay? Minimum standard of treatment. You talked about clarifying the FET. Well, it's pretty clear over here. That is, FET now becomes the international minimum standard. Denial of justice, anyone? You have to now prove, according to the U.S., it shocks the judicial conscience what the government has done, okay? So it's a narrow test. Now, what gets the U.S. is that it has convinced the NAFTA tribunals that that's what it means, because under the NAFTA you can issue an interpretation. But what have the NAFTA tribunals said? Okay, we'll accept that that's what you always meant by fair and equitable treatment, that is equal sign customary international law. But custom evolves. And what shocked the conscience in 1926 is different today. We're more easily shocked by what a government does. So, and that's my point also, is keep in mind, this treaty is now 50 pages long. This used to be 25. Everybody knows as you get a longer treaty, the right shrinks. Well, that's what's happening. But no matter how relatively precise you are, an arbitrator still has room. So even here, telling them it's custom, all of a sudden custom evolves, right? And so you may still have a more generous treatment than the states anticipated. So I'm not saying this should be the treaty if Brazil were to do it. This is it. But this is a much, much more sovereign protective treaty than I suspect they were looking at when they told you they were investor protective. Now, the latest U.S. model is 2012. It's pretty much like this. This is typical Obama administration. They put a committee together, 3 years of study. Okay, we'll settle on this one. Okay, they added a few provisions, hesitating on sovereign wealth funds or something, but really the ripples are very close to this. So here's the fair and equitable treatment. Here's the definition of full protection and security, also reduced to customary international law. Here's the definition of customary international law, just to be sure people understand. It's not whatever the General Assembly says from time to time. Expropriation. This makes sure, or tries to make sure, that regulatory expropriations like the one that I've suggested, where it's measures, general measures that reduce your profits, generally speaking, would not be a taking. And in fact, it goes so far as to do this. Where is that wonderful clause? Annex B. So it goes on in this annex, and this is what is now in place for Peru, for Singapore. It says that in order to figure out whether it is a regulatory or indirect taking, you have to do this balancing test back here. You judge the economic impact of what the government is doing versus the extent interferes with a distinct investment-backed expectation. These three tests, where do they come from? Penn Central, a U.S. constitutional case on the interpretation of the U.S. Takings Clause. So this is exporting U.S. constitutional law and trying to say you're not going to get any better than what a U.S. national would get under the U.S. Constitution. Brazil could do the same. Brazil could say, here's our constitutional law on takings. This is what we expect. I don't think this works, by the way, because it's the balancing test. It doesn't say whatever the U.S. Supreme Court decides from time to time. And so an investor, arbitrator, is going to use the balancing test. But their results may be different from what the U.S. Supreme Court says from time to time. And in 200 years, they haven't come up with a very good and dependable takings test. But these are examples of what I'm suggesting. Now, transparency has now been made not arbitral, which is another thing you could do. You could say some rights go to arbitration and some do not. Right? So I just raised this to highlight what I think is a more general point, which is Brazil, like China, like the United States, and like many countries, is both a capital exporter and a capital importer. I consider those countries to be in John Rawls' original position. You never know whether you're going to need it one way or another. You need it for your exporters of capital, but you're also going to be subject to it as a host state. So I trust those governments to create a fairly balanced agreement between the rights of states and the rights of investors. And I think this model comes close, but you're welcome to do more. But my point is that we may not need a multilateral agreement on investment. We may come up accidentally to multilateral regulation because more and more countries are going to come up with this. That is, European Union is now going to have to negotiate its own treaty for all of Europe under the latest treaty of Europe, if there is a Europe. But if there is, they're going to negotiate, I would suspect, something that looks like this. China already has something that looks like this, and the U.S. has this. That's an awful lot of capital coming in and out, already controlled by similar rules. Not identical, but similar. Do you need an agreement when you have that and the pressure that that creates? Now, with respect to Argentina, well, I've said enough about Argentina. Let me just go back to your point about Brazilian investors abroad. One thing that Brazil might consider, if it was going to tiptoe into this, is conclude treaties with Angola and Mozambique, right? And if Angola and Mozambique want Brazilian investors so much that they want to conclude a bit with you, even though there's precious little of Angola and Mozambique investment here, are you going to say no? Doesn't that sound a little condescending? That is, why not? I mean, the U.S. bit list looks like this. Albania, Armenia, Azerbaijan, Bahrain, Bangladesh, Bolivia, Bulgaria. That's just in the B's. These are all countries that do not invest in the United States, but all countries that want enough, either signaling or otherwise, to sign treaties with the United States. So there's no stopping, as far as I can tell, unless there's domestic political reasons, to sign treaties with countries in which Brazil invests in, even if there's precious little of those countries' investments here. And I do think that if those countries want it, who are you to deny it? Okay, questions?
I just wanted to expand on the professor's question here.
and you explained a bit about how there's this tendency towards, regional elaboration of different bits. Now, I wanted to know, is there, also sparked by the controversy of the Argentine cases, is there interest from an international organization such as the WTO to bring these bits, kind of merge or fuse them together and come up with something that is a international model that lays down the ground rules and regulates what are the minimum requirements of a bit and what can or cannot be in one of these agreements?
Well, I think you alluded to the problems. The WTO has tried to be the venue for investment negotiations, and it was an open-ended question at Doha whether they would. But the fact remains that the 150 or so countries, 153 or whatever it is that are the WTO, do not feel, for one reason or another, either that there is a need or that this is the right place. Now, at the OECD, the negotiations collapsed in 1998, in part because it was perceived that this was a rich club imposing the rules on the rest. And that was a bad thing in terms of optics, certainly. But actually, the negotiations collapsed when you looked more closely because, in part, of very serious objections from the perspective of the Canadians and the French, who thought that this would strike at French cultural and linguistic dominance. That is, they thought that this would prevent French government subsidies to publishers, to movie industries, and so forth, and that this was a strike against francophones around the world. And that was generated also by NGOs and others. So it was a cultural exception that they wanted, which, of course, was not favorable to Hollywood. And so that helped to bring down the whole thing. But that suggests the difficulties of multilateral negotiation. Now, there is always talk of bringing this back, maybe not under the WTO, since that failed, maybe not under the OECD, since that failed, but maybe under some other auspices, UNCTAD or some other more neutral place. But the bottom line is you need not just all these states, you need the stakeholders involved here to be interested. And one of the slides I did not put up is the stakeholders involved in this regime, which include business. They have to support this because what's the point if business is not behind it? So when Norway released its model bit, that was let's just say, a center-left dream of a bit, the business groups in Norway said, that's nice, but we don't want it. And so if the business groups don't support what you're putting, you could go too far here. And that's the problem the Obama administration faced. Some of the labor groups wanted either not to have these treaties or to eliminate investor-state arbitration or to reduce it to only national treatment, for example. And the business groups in the U.S. said, we're not interested if that's all you do. So one of the problems in multilateral is, what do you do with the existing treaties that grant all these rights, right? Are you going to take them away in favor of the least common denominator rules, these minimum rules of the road? Minimums don't do anything if you have maximums through MFN, right? The same thing, Europe is facing the same problem. That is, Europe is now supposed to negotiate bits on behalf of Europe, but what do you do with the over 150 very favorable bits that Germany has negotiated for itself and still exist? Are you going to just grandfather those in? Then what's the point? So there are complexities here of the rights that you've already accorded, people who have sunk expectations based on those. Keep in mind that this treaty, for example, and many of them, last for a minimum of 10 years. And then if you decide to terminate, existing investors that came in get another 10 years of protection. So you're talking a long period of time before you can do it. Incidentally, Argentina's treaty concluded in 1992. Last I could tell, they should have announced they're terminating it. They haven't. I wonder.
Hello, my name is Salim Nasser. I teach international law here at the school. I hope you will allow me a more theoretical question.
I do think.
Mention was made to an ensemble of rules that are not only in 3 levels of public international law, multilateral, bilateral, and regional, but are also in customary international law and are in national domestic legislation or regulation. And also you have mentioned soft law and other instruments. Not only that, the ensemble also includes institutions, dispute resolution mechanisms that also are linked either to international, public international law, or to regional arrangements, or to domestic legal systems. And they, of course, this ensemble does not operate for all actors in the same way. Mm-hmm. So each state, each stakeholder is, in fact, subject to a different set within this more general set. This ensemble has been called or named a regime all throughout the presentation, and of course there must be an implied concept of regime, an implied definition of regime. I have been writing on this, so this is why my interest is sparked by this. This implied concept, is it only a fluid concept, something that is just used in a very light way, or does it have more substance, and does this concept mean something, and is it important for it to be very clear as a concept, considering, of course, that, as I was saying, it relates to several legal orders and also to non-legal regulation, right, and also subjects different actors in different ways.
Very good question. So in the Hague lectures that I have, and you're welcome to Amazon, paperback, you will see a discussion of regime because it's in the title. And I draw it from the political scientists' description of what regime is, including the convergence of expectations. And I use it purposely as opposed to system, which is, I think, considered a more coherent account. That is, I think there are convergences here. I mentioned what those are. Those are the standards. I also think they're united in the sense that certainly all the folks, including the stakeholders, including the arbitrations, are working under the Vienna Convention rules, including the rules for fragmentation and defragmentation, which include Article 31.3c of when you can reach for those other rules or not. And there's a whole section in the book about fragmentation issues in this regime. And I can't do justice to the problem, but there is, I think, in the literature, in the more theoretical literature, what I call an urge to merge. That is the sense that it all should be applied. Whether it's human rights, environment, we should be free to draw on anything and everything here. And I think some of that is because of the ILC's, what I call the defragmentation project, which, if you're not familiar with it, is worth reading. It gives you standard rules that I actually happen to agree with as to when you should fall back on different rules, and I actually agree with their rules as an approach to lex specialis and others. But what I see, one problem in some of these cases, and I've written extensively about one of them, Continental Casualty v. Argentina, where what they did through the urge to merge is they reached for the interpretation of GATT Article 20 and used that to interpret that middle clause on that page, which doesn't look anything like Article 20. So you see in that distributed sheet the U.S.-Argentina measures not precluded clause, and the debate is whether or not it reflects the customary rule of necessity or what it means. If you don't agree that it means the customary defense of necessity, which is Article 25 of the Articles of State Responsibility, does it mean something necessary. Use the words, right? Instead, what they did, instead of applying either the FCN language or Article 21 of the GATT, which talks about essential security, is they went to Article 20, which has nothing to do with essential security, ignored the Chappelle clause in that article, which says you get to whether it's necessary for one of these A through J only if it's not protectionist, and then applied a necessity test that doesn't, in my view, exist in the WTO, absent the proportionality test of the Chappelle clause. So I think that is what I call premature and wrong defragmentation. That is, when the states purposely create a regime, you apply under the Vienna rules what its plain meaning, text, etc. means. And that you shouldn't reach for things that have a different text. One of the reasons that I put the differences between the WTO and this regime is to get people to focus on this is a very different regime in terms of its purpose, in terms of its remedies, in terms of who controls it. And the states purposely did that. Now, we may not like the fact that, as I say in that book, the most protected human right on the planet is the right to property under this regime. That's what the states have created. It's our job to change it by changing the treaties or by convincing investor arbitrators where it's possible to balance rights of, say, human rights and fair and equitable treatment in terms of, say, the economic crisis. But that's a long way of explaining that, yes, I do seriously consider this a regime, but not a system, and that there are serious fragmentation and defragmentation issues here. In fact, the last chapter in the book relates the regime to 10 challenges facing public international law. Fragmentation is one of them.
Well, my question is about the most favored nation clause, and how will it work? Because you were saying that maybe we won't need a multilateral agreement on this because we will have a model that will be used by United States and Europe and China, and maybe we'll have all the capital under the same rules. But with the MFN clause, and whether it's applied like it was applied, I don't know if it's the Ablacat case or another case, and you can expand the protections that are present in other BITs to a BIT that doesn't have it. Maybe we already have a multilateral framework protecting all investments. So how do we stop that? Because maybe it's not the intention of the governments to have all the same protection. If they wanted that, they would have made multilateral agreements. So my question is, can we stop that? And how do we do it?
The first one, what do you think are like the actual effects of the ICSID denunciation by Bolivia, Venezuela, and Ecuador? And now the threat with Argentina. Because as far as I'm aware of, I think that most of the bids signed by these nations anyway include an arbitration clause under the additional facility or UNCITRAL. And there's this kind of paranoid nowadays because of the possible denunciation of Argentina. But in the practical sense, there's actually not great difference other than obviously the protection under ICSID. But the protection granted by the arbitral tribunals, the arbitral rules, seem to be similar. So I don't see any other but political statement, as you mentioned at the beginning of your presentation, regarding this denunciation. And my second question goes to the retaliation. This is more like regarding to probably the most recent case, which is the Repsol YPF case nowadays, the Argentina expropriation of Repsol, the shares of Repsol in YPF. And going back to this issue that has been dealt with today regarding the possibility of a multilateral treaty, I'm not familiar with the BIT or the bid between Spain and Argentina and the terms of it, but it is clear that this time a national champion has been hit. a Spanish national champion. So there are clear evidence. There's clear evidence of a possible retaliation by the government of Spain against Argentina. I don't know if a bid can actually cover this enough. The WTO, for example, allows a common field on which the retaliation is not free by the member states. Therefore, I would like to know your opinion about this, about how do bids could cover this potential retaliation, especially when national champions are the ones that are affected by national measures.
Professor, regarding the likely denunciation of the Washington Convention specifically, would you say that to what degree does the Washington Convention allows investors a better protection than the New York Convention in terms of arbitral awards? Aside from the execution, I'm thinking about annulment procedures. If the standards are quite similar, then how would you reconcile that? Thank you.
Okay, these are great questions, and let's start with the MFN. So what the U.S. has done, which does not show up on this, but it shows up in each one of the treaties that have been negotiated under this, is that it's restricted the MFN clause so that you cannot reach back to the better clauses in U.S. treaties. Now, that's not a perfect way to deal with the MFN problem, but it's a way that the U.S. is trying to control the scope of this. What other countries have done is, for example, I think China has done this, is that it says from now on, MFN does not include procedural requirements like 18-month rules, right? So you can limit the scope. However, you are right that Stephen Schill has a whole book called The Multilateralization of This Regime, and he draws on the MFN as one way that this regime has become multilateral, not just through nationality shopping and bit shopping by investors, but through the MFN clause raising the level. So those are serious dimensions, but there are ways to at least forward deal with the MFN issue. Now, the second question, I actually have not looked closely at the Spanish-Argentina treaty, so I'm not sure exactly what it says. But keep in mind that what we have in many treaties, it could be in that one, is a state-to-state clause as well as investor-state clause. And so you can imagine that if the Spanish government were to take certain action, you can imagine Argentina filing a state-to-state claim as to whether that is consistent with the BIT, right? The other thing I would say is that even if you didn't have that option, the whole goal of this regime was to get away from gunboat diplomacy of the 19th century, going back to your concerns about this. The whole point of this regime as the WTO is the notion of giving this to the investors so that the two states are not at each other's throats, right? And what you're suggesting is when it's a national champion, they are at each other's throats. And even if that national champion chooses to file an investor claim, given Argentina's civil disobedience in failing to pay any of these claims, you could understand the Spanish government being a bit dubious about getting anything out of that. So there's always a temptation, and this is, I think, partly caused by Argentina's defiance, that the whole system breaks down because ultimately, as you will know, international law is not very good on compliance, despite Lou Henkin. That is, getting money from a sovereign is always tough. Sovereign immunity is a tough one to overcome, the actual execution of it. So the one thing, the ICSID regime was structured and tried to entice and successfully did entice so many states, including Latin America, to sign that because it says that once you are in this, you don't have diplomatic espousal, never mind gunboat diplomacy. The whole trade-off was the U.S. is no longer free to try to defend this investors and going straight to the diplomatic mission of these countries. So it cannot go to Argentina and demand this, instead of this. However, what is happening in the wake of Argentina cases defying payment? The Obama administration has just denied GSP treatment to Argentina. So we're back. At some point when the system collapses, you're back to governments at each other's throats. I happen to think that's a bad thing.
right? Because that's the whole goal, is to prevent that from happening. But and it's not just going to be just the U.S. The U.S. is obviously trying to get allies, and if the situation gets bad enough, they will try to get enough allies to deny the next loan if Argentina ever needs one. Market players are involved. Market raters are involved as to Argentina's credit rating. There are all sorts of devices that international law, loosely said, has to enforce. And pressures and including threatening gestures by the government of Spain is all part and parcel, whether they actually do it or not. Now, the question about what's the point of ICSID denunciations, I think partly political. But keep in mind that in this particular treaty, for example, the one that I was describing, the only remedy was ICSID. So not all treaties provide this wonderful, soup of possibilities. And that, in fact, some investors prefer ICSID because it's a self-enclosed system where the annulment system is there. They don't have to go to national court for annulment, which is one difference, right? It may be the same grounds, but in one case for annulment, but in one case it's a national court that is considering this, which you have less control over, and in another it's an ICSID committee. Now, given recent ICSID annulment committees, whose results I disagree with, I'm not so confident anymore that the ICSID process is better. But keep in mind, most of these disputes up to now have been in ICSID. Now, I guess there was also a question on transparency embedded in this. ICSID is the most transparent. So that is, we have ICSID awards being public. We even have, on occasion, proceedings in ICSID with televised proceedings in ICSID. Into the NAFTA, every piece of paper that is filed in a case is now public. So the public pressure on ICSID to make everything transparent is huge. So it could be, I'm not saying it is, you could denounce ICSID in part because it's public. That is, keep in mind that secret negotiations over investment disputes is something states sometimes want. Cuba has 62 bits, more than the United States. I somehow suspect there have been some Cuba investment disputes. I don't know, maybe it's because I'm Cuban. But there's somehow very little evidence of them. That is, it's all secret. Why should we be surprised if a government that is mostly secret internally should be mostly prefer secret externally? So if you think that applies to Hugo Chavez, that's your problem. But still, that is the idea here, is maybe we denounce ICSID because it's so transparent. And that is, maybe we want to keep some things among ourselves. I hope that answers most of those. Thank you.